Court of Appeals Division 1 is now in session.
Thanks. You may be seated. We're here on our case number 1, CV170443, AMARI versus Scottsdale Healthcare Hospitals et al. Counsel, as you know, both sides, or each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself. The clock on the podium reflects the total amount you have remaining, including what you might have decided to reserve. We record these proceedings, so we'd be grateful to you if when you approach the podium, you would give us your name and the name of your client for the recording. We have studied the briefs and closely reviewed the record in the case. We've also discussed the case in our conference. So with that, you may proceed.
Good afternoon. May it please the Court. My name is Allison Chase. I'm with the law firm of Keller Rohrbach, and I represent the plaintiff appellant, Ms. Amy AMARI. At base, there are fundamentally two issues in this appeal. The first is whether Ms. AMARI, consistent with Rule 15, should have been granted leave to amend her complaint to make clear and to add detail regarding her allegations of long-term emotional distress and its physical manifestations. The second issue is whether this Court should alter the so-called physical impact rule under Arizona law. I will begin with the issue of leave to amend. Under Arizona law, damages for emotional injury are recoverable where there is a physical impact or the emotional distress has manifested in some physical way or is long-term. That is the Keck, Quinn, and Monaco line of cases.
So long-term physical illness or mental disturbance.
Yes.
Does long-term modify mental disturbance as well? It does, doesn't it?
I believe long-term modifies mental disturbance under Monaco.
And physical illness, I guess, as Monaco says it.
I think that's correct, yeah. I could look at the language if you give me a second.
I've got it in paragraph 8, I think.
Yeah. It does say, on the other hand, long continued nausea or headaches may amount to a physical illness, which is bodily harm, and even long continued mental disturbance, as for example, in the case of repeated hysterical attacks or mental aberration, may be classified by the courts as illness, notwithstanding their mental character.
Got it. Okay. Thank you.
Now, with respect to emotional distress, Ms. AMARI alleged both that she had suffered physical manifestations of her emotional distress and that it was sufficiently long-term to qualify so as to be a predicate for emotional damages under the Monaco case.
You say she alleged that. When did she first allege that?
I would say that she first alleged that in her initial complaint. It was not alleged in detail in the initial complaint or the first amended complaint. There was a bit more in the second amended complaint, but at the point at which she really sought to add the detail was after there had been the dismissal without leave to amend.
Isn't that the first time she alleged there was a long term?
I don't believe the first time that she alleged a long term was in the Rule 59 motion. I believe it was within the initial complaint and then this first and second amended complaint. If I could, though, I'd like to walk through
where in the first complaint was that allegation?
Okay.
Or the second complaint?
I believe the complaint and the first amended complaint both alleged, quote, foreseeable and unavoidable concern and anxiety, resulting trauma caused to each of the patients, and the typical financial and emotional impact. And that's paragraph 2, paragraph 43.
Well, that doesn't say long term.
It might not. I agree. That does not say long term. I don't have a quote specifically for long term. But what I would like to focus on for a second, if I can. Oh, sorry. Let me get to the second amendment complaint because you asked about that. It did say she lost sleep over several nights processing the news. She had worried about future health effect, insurability, what to tell a future sexual partner about her exposure, and additional impacts. But what I'd like
Again, though, she did, I mean, in going through this, it doesn't seem that she even mentions the term, that it was long-term or give description of long-term until you get to the Rule 59 motion.
But I think that's why I wanted to focus on the timeline of the amendments, if I can, for a second. And the first complaint was on May 3rd of 2016, and that was an initial complaint. It was a class complaint. There was one First Amendment complaint about a week later, but that was only to correct a matter of form. That was just to correct the corporate name of Honor Health. They had not even been served yet. Honor Health moved to dismiss, and they stipulated to allow Ms. Amari to amend her complaint. But that stipulated amended complaint focused only on the physical impacts of the blood draw. She had never at any point up to those two complaints amended to add the long-term emotional distress allegations.
Well, didn't the defendant's motion to dismiss the first amended complaint raise the issue of the long-term, the lack of a long-term allegation?
I had thought, honestly, when I read it, that the focus of the first was, was the lack of a physical impact. Because I thought their theory was, if I can look at it for just a second.
If you don't, that's fine. But would you agree that by the you get to the second amended complaint that was one of the bases upon which they moved to dismiss the
Yes,
second?
it was. And to be clear, during the oral argument, I know that Honor Health says that there was no, Ms. Amari didn't seek leave to amend at oral argument or make these allegations. But I think if you look at that November of 2016 transcript, first off, Honor Health did acknowledge that those allegations were there. There was a long colloquy with the trial court judge where plaintiff's counsel, Ms. Amari's counsel, said, well, if you think this isn't good enough, please give us leave to amend. We'll go back. We'll make clear the long-term nature of these allegations. There was definitely a request for leave to amend to make clear those allegations, and I think that is at page 23 to 24 of the November 2016 transcript. The longer colloquy about the nature of her damages is about, I think, pages 17 to 20. And if you look in that, the trial court does say, well, I think she's just talking about a couple nights' sleep. And the response is, well, I think that understates it. But if that's what's coming through in the complaint, please give us an opportunity to amend those allegations to make that more clear. Those allegations were never amended, and Ms. Amari was never given a chance to amend those before her case was dismissed without leave to amend.
Here's the question I have. I take the affidavit that was submitted with the Rule 59 motion.
Yeah.
It is so detailed.
Yeah.
And on review, it's almost as if the argument is it's almost as if we're looking at this on summary judgment. Is this is as good as it's going to get?
It is,
presumably,
probably.
So does this? I mean, are we to look at this and evaluate whether these allegations are sufficient to support a claim?
Well, I think, yes, you should look at whether those allegations are sufficient to support a claim, because that is, in effect, that is Ms. Amari's proposed amendment to her complaint. Those are the facts that she sought to allege and would allege in an amended complaint. And I think, importantly, when you look at Honor Health's brief, they don't really argue that those allegations don't meet Quinn, don't meet Monaco, that they're not sufficient to state a claim. They go a very different way in seeking to show that those allegations that are in the Rule 59 motion that Ms. Amari wants to make to add to her complaint, the facts she wants to plead, what they say is that they're not good because you have to cut off her damages by a rule of reason.
That's what they say. They say after 10 days or
Yeah.
9 days that anything she felt was unreasonable and therefore not recoverable.
Yes, that is what they say. And I think that's very telling for two reasons. The first is I think that really is an admission that what she's saying in that affidavit is sufficient to state a claim under Monaco, under Quinn, and under CAC. They don't say it's insufficient, what she wants to plead. What they say is you have to cut that off. But I think that argument, that rule of reason that they are arguing for, it is inconsistent with Arizona law. I think first, if you look at the cases they rely on, they're from Tennessee, which has a different rule on damages. They're from New Jersey, that has a different rule on damages. They're from New York, which has a rule of reason. That's not the rule here, and as we cite in our brief, Raji 2 says personal injury damages, unusually susceptible plaintiff, quote, plaintiff is entitled to compensation for all damages caused by the defendant, even if the plaintiff, quote, was more susceptible to injury than a normally healthy person would be. And Ball v. Prentice say the credibility, the amount, and the causation of those damages are for a jury. So I think if you're looking under Arizona law, those allegations are clearly sufficient because Honor Health has to go to New Jersey, to Tennessee, to New York to find a way to say that they aren't.
Well, let's assume, for the sake of argument, that we reject the notion that the rule of reason applies to this, and we treat this, and I know they have procedural arguments that I'm sure they're going to argue to us, but we treat this as the amended complaint.
Those are the facts that she would amend, yes,
In
add
her
to her
complaint.
amended complaint.
So could you direct me to where in this complaint you're alleging long-term, substantial physical injury or mental disturbance?
Yeah. Okay. With regard to the length of time, Ms. Amari says that,
Could you give me a paragraph?
yeah, pages, it's excerpt of record 30, paragraphs 5 to 11. I believe she says that her physical symptoms began after she received the notification of her exposure in March of 2016. The symptoms intensified following her blood test, so that was a week later, I grant you that. That's paragraphs 12 through 17. Her symptoms intensified again upon learning that Rocky Allen was HIV positive, and that was many months later, after she had the negative test. Again, that's 12 to 17. And then towards the end of her declaration, I believe she says that her symptoms were ongoing and continued to manifest for several times a week. She says they decreased for some time, but they still come up several times a week that she would have those experiences in paragraphs 19 to 21.
But she says in here that they decreased, she didn't experience them, and then she experienced them again. And then she has a conclusory statement at the end in paragraph 21 where she simply says, and continue to suffer them.
Yes, because it's ongoing at the time, and obviously the record gets ossified at a point when, the complaint is dismissed, the record is closed. So she can only, say they're ongoing up to the point that she makes that declaration. But the fact that they might decrease a little bit doesn't mean that they're gone.
Well, except she says, I have all of these things back in the previous paragraphs, some of which I don't think sweating would qualify. So without any further explanation on what symptoms are continuing, how, if we accept this as you said to Judge Johnson, this is as good as it gets, how can we then say that she has made an allegation that would be long-term significant physical injury or emotional disturbance?
Two things. First of all, if you are saying that it seems to me that you are picking at one point of her declaration, which you're saying it does not connect the specific symptoms with the occurrence of the symptoms, which is something I think she probably could add more detail. If you wanted to know how frequently she is getting headaches or she was getting headaches, that is the sort of thing I think she could probably plead in more detail. So what you're saying is that you don't find sufficient specificity connecting the specific symptoms with the occurrence of the symptoms. I think what she does say, for example, with the waking up at night and experiencing the sweating and the hyperventilating and the panic attacks, is she does say they do occur a couple times a week. She has loss of concentration. And so I guess I would say that I think sweating alone, maybe if you isolated it, sweating alone wouldn't be enough, but you're talking about panic attacks, you're talking about headaches, you're talking about a loss of concentration. And in that way, they are kind of similar to what was going on in the Monaco case, where it was a combination of symptoms that were ongoing and long-term and interfered with daily activities. And I think the combination of the symptoms here is what it is. But in any event, whether those are sufficiently weighty to be entitled to compensation is really a question for the jury under Ball versus Prentice and a line of Arizona authority, I think. Now, if there were no impact whatsoever, or if it was just transitory, I would agree with you that maybe that's not enough if she had she sweat occasionally about it.
Is there anything in that affidavit that reflects a formal diagnosis of a permanent condition?
I don't believe there is any indication in the affidavit of a diagnosis, no. But I also don't believe there's any requirement of a diagnosis in order to state a claim. I didn't see that in any of the cases.
The cases, as you just said, and the cases do draw a distinction between transitory and long-term.
Yeah.
But isn't that a legal conclusion versus a factual conclusion for the jury?
Well, I think what is that? And then you're asking the question of what do I consider transitory and what do I consider long-term? I think long-term is a couple months going on a couple years, which is what we have in this case. Transitory, I think, is once a week, maybe for a month or two. I think what she's describing crosses the threshold from transitory into something more serious than that. I don't believe that there is a definition. I don't know if there's a definition of transitory in the law off the top of my head. For example, from Blacks, I couldn't cite that to you.
How can the court, this court, say it is one or the other?
Is there guidance in the case law? I don't.
Right, we don't.
I don't think there is clear guidance in the
We don't have
case law.
Arizona law under Arizona legal principles that say that 10 days is not long enough. Do we?
I don't think that there is a case in Arizona law that I'm familiar with that defines transitory as being more than 2 weeks, less than 2 weeks, but long term as more than a month.
Did you want to talk about impact?
Sure. Actually, I'll just reserve the rest of my time for rebuttal. Thank you.
Good afternoon. May it please the court. My name is Colin Ayler. I represent the defendants' appellees, who I will collectively refer to as Honor Health. Also, throughout my presentation, I may use the term NIED to refer to claims of negligent infliction of emotional distress. This case is about a plaintiff seeking recovery for something that did not happen, specifically a fear of disease for which she has tested negative. The Superior Court judge, Judge Mullins, carefully considered her allegations. She looked at the Arizona cases on the bodily harm requirement, and she correctly determined that that requirement could not be pled. And no amount of complaint amendments can remedy that defect. And there was a suggestion by counsel that we somehow admitted that their affidavit stated a claim, which is absolutely not correct. Our position is that whether that affidavit is considered or not, they cannot state a NIED claim.
I thought the argument that Honor Health was making in its answering brief as to why the allegations in the affidavit would be insufficient is under the out-of-state cases. One, as a matter of law, may not recover for emotional distress suffered after you get the good news that you're not positive.
That's correct. And the cases, while they are out of state, have been clear and unanimous that once you're in receipt of that negative test result, as a matter of law, there's no more recovery for fear of HIV.
Do the states in which those cases arose have the same susceptibility rule that we do when we allow damages here in Arizona?
They do, Your Honor, and when you talk about that susceptibility rule, that's really just another way of saying the eggshell plaintiff rule that's been around hundreds of years.
What's the authority for that in Tennessee and New Jersey and I forget the other state that allow though? Because the language that's cited in the reply brief is plaintiff is entitled to reasonable damages or reasonable time.
Well, I think the distinction here, Your Honor, and I can provide those authorities, but at the outset, eggshell plaintiff rule is talking about fundamentally a different issue. It's talking about once liability has been established, how do we measure damages? These fear of HIV cases that we've cited are talking about different issue. They're talking about whether there's liability in the first place. For example, the D'Amelio case from New Jersey talks about it in terms of approximate causation issue, that the fear of HIV is not reasonable once you're in receipt of that negative test result.
Well, say the test results here took a month to come back. Would she have a claim?
Well, and so then the question is whether that month you're waiting is in the transitory category or has it turned long term.
And who decides that?
I do agree that that's a determination that should be made as a matter of law. I agree with counsel that there's no case setting forth a bright line as what that time period is. The one case I would call to the attention of the court is, where it did talk about duration, is the Gow v. Smitty's case, There you had a plaintiff who had 2 months of emotional distress, as well as physical manifestations of the distress. And the court there said 2 months is not enough. And so 9 days is obviously a lot less than 2 months. And so as a matter of law, we're arguing that 9 days can't be sufficient to meet the bodily harm requirement.
Was that a summary judgment case?
The Galvey Smitty's? That was a case that
Was it a summary judgment case?
it was not, Your Honor. It actually came back after trial, and the appellate court determined that a directed verdict should have been entered in that case.
But it was after a full evidentiary airing of it. What's the case that says that a decision about whether the distress is merely transitory or long term is for the court to make as a matter of law? Where's the case authority for that?
Well, I think it derives from the restatement, which initially made that distinction, talking about the transitory versus the long term.
I'm sorry. I didn't ask the right question. What I meant to ask is, where's the authority for the fact that that decision is for this court to make rather than a jury?
I can't recall the specific language for you. I believe that was part of the Burns decision, which was summary judgment, but did talk about this, the same types of manifestations that have been that the plaintiff has alleged here, and said that they were merely transitory, and so those couldn't serve as a basis for bodily harm.
So, and if a plaintiff, if in this case, from the date of testing to the date of getting the results back was what, 2 days?
Correct.
So if in that 2 day period, if we just focus on those 2 days from the date of testing till they get the results back, if that period of time manifests itself in a long-term mental disturbance, cause PTSD or whatever, is it your position that that would not be sufficient as a matter of law to go forward?
Yes, that would be our position. I know that as well that has, of course, not been alleged at any time in this case that there's any sort of PTSD developed in the 9-day period of which she was uncertain about the test results.
Well, but from the date she got the letter until the date she got the test result, caused, from what's being alleged, has caused some type of emotional distress. And my question is, if during that period of time it created some long-term emotional disturbance and or physical injury, because it's or, then isn't that sufficient? I mean, we don't just simply cut it off after she gets the results back, since the alleged injury occurred before that time, don't we?
I don't think it is sufficient, because what the restatement talks about, as well as Monaco and the Burns case, is that it's just not, you can't just look at the severity of the distress or the manifestations of the distress. It's also the time span, the duration of how long it lasts. And so when you look at that, as well as look in the fear of HIV cases, it says, once you've got this negative result, as a matter of law, you cannot recover anymore.
But, counsel, let's say you have a soldier in a war, and there's a bomb, and it goes off, and that begins what we call PTSD. And there's no continuing threat of incoming missiles, but he's going to continue to have and wake up for years to come. So if here we had what was a very shocking moment, let's say the plaintiff became very concerned about her health, which resulted in PTSD as a formal diagnosis going forward, you're saying that would not be recoverable?
I would say no, because under the authority of the fear of HIV cases, regardless of whether it's PTSD or not, the fear that's being felt is a fear of contracting HIV, which has been already been resolved once that negative test result is in your hand.
Diagnosis?
I'm sorry?
Even if you have a diagnosis? Well, I recognize that's not this case.
Yeah.
That's an extreme position to take.
I mean, I guess
You're saying no matter what, after that 10-day period, that no matter how much mental disturbance was created during that 10-day period, as a matter of law, we simply cut it off at that moment because it may be unreasonable to everybody else, but to the particular plaintiff, they should know better. Is that what you're telling us?
I believe that's right. I believe that's the principle that comes through the fear of HIV cases. And I'd note that the Plaintiffs' Counsel has never actually questioned the rationale of those cases. They've simply said that, well, they don't apply because Arizona has an eggshell plaintiff rule, which we've talked about. Well, all these other states, the 6 other states where we've cited authority from, they have that rule as well.
Well, but you didn't say so in your answering brief, though. I mean, really? So the other states as well? If that's the case, then why do these decisions say it is unreasonable and therefore we will not allow recovery?
Well, again, Your Honor, because I think they're speaking more in terms of the question of liability versus the measure of damages. Just to give you one example, we've cited a case from New York, the Brown case on fear of HIV. New York has pattern jury instruction civil 2-283, which pretty much mirrors Arizona's jury instruction on the unusually susceptible plaintiff. And there's a list of authorities from the other states as well. But the notion that all 6 of these states have rejected the eggshell plaintiff rule has just never been supported by any authority by plaintiffs in this case.
Assume we disagree with you. Do you believe that the affidavit in this case alleges a substantial long-term physical injury or emotional disturbance?
I don't believe that it does, for some of the reasons that were raised earlier in the oral argument. In our briefing, we focus more on the legal principles in the fear of HIV cases. I think one thing you can compare it to is the facts of Monaco, where there actually was a diagnosis for PTSD. And as the court has noted, there's been no sort of diagnosis like that or diagnosis of any condition arising out of emotional distress in this case. Unless there's any other questions on that, I'll quickly turn to the physical impact issue, which was not addressed by plaintiff in her opening presentation. But on this issue, we have a case, Transamerica v. Doe, that's almost directly on point. It looked at a blood test for HIV and said it's not a bodily injury. Plaintiff has responded that Transamerica was an insurance coverage case, so it should be ignored. A couple of responses to that and why we disagree with that assertion. First of all, the court in Transamerica made clear that the insurance policy did not actually define bodily injury, and so the court had to interpret that term according to its common sense, ordinary meaning. Second, in determining whether a blood test was a bodily harm or not, it's notable that the Transamerica court looked to the NIED cases from negligence law. Specifically, it repeatedly cited both Burns and DeStories, which, similar to this case here, involve claims for fear of disease. And the third point I'd mention is that the Transamerica holding was based on the same policy reasons that were discussed in Burns. In particular, that we don't want to create a system where you're giving a windfall to healthy persons while potentially creating insufficient compensation for people that have actually been injured.
Counsel, you start off your brief with sort of a theme that no good deed goes unpunished. Are you suggesting that that has any place in our decision, that the hospital reached out when it didn't have to?
I think the relevance of that is, there's been an assertion by the other side that we're trying to immunize hospitals from any liability, which is not the case at all. If someone had actually contracted a disease at Honor Health facility, we'd be here on a completely different case. I think the relevance of that authority, and it kind of goes back to the policy reasons I was just talking about, there's really no reason to lessen the bodily harm requirement in this case if you're going to effectively deter hospitals, medical professionals from giving notice to people to say, hey, we've had an incident, you should get tested so you can have peace of mind that you're actually healthy. Last case I'll talk about is the Ball v. Prentice case. Plaintiffs have made the argument that Ball is somehow in conflict and contradictory to Transamerica. Again, that's just not correct. As an initial matter, Ball did not involve an issue about a common diagnostic test like Transamerica did. One interesting similarity in the two cases is they both arise out of car accidents. The difference is, in Transamerica, the plaintiffs weren't actually participants in the car accident. They were instead good Samaritans who saw someone who was injured and went to help them, and in the process were exposed to some HIV-infected blood. Compare that to Ball, where the plaintiff is an actual participant in the accident, physically impacted by the collision, suffers physical injury. And that's a critical difference, because what the Ball court said is that if you're relying on a physical impact to satisfy the bodily harm requirement, then that impact needs to be what triggers the emotional response. And it's interesting that the plaintiffs have placed such great weight on Ball, at least the parts of it that they like, while ignoring the parts of Ball that talk about that causal nexus between the bodily harm and the distress.
Well, although it seems to me that that law, that legal principle, is stepping away from the blood test or the diagnostic test results. All the cases that I learned about in law school a long time ago about how if you are bruised, all bets are off. Matter of fact, one of the briefs cites some great language from a decision. You know, the panoply of damages is there. So I don't think that historically the cases say that the mental distress must come from the impact. I think the cases have upheld that rule because the impact is some validation of the reality of the mental distress. Isn't that right, really?
Well, if that's the policy, that's not really what's happening here. It's not, the subsequent blood test isn't really validating whether the distress was real or not. It's just a test to determine if you have HIV or not. And I mean, I do think that causal nexus is important because, as we've talked about, there's basically two ways you can meet the bodily harm requirement. First, you have a impact on your body that turns into distress, or the second way is the one talked in Monaco. You have distress that's so bad and long term that it itself turns into the bodily injury. So two ways to meet that requirement, but either way, the distress and the bodily injury have to be tethered together. Otherwise, you're creating the problem that was discussed in the Keck v. Jackson case, the Monaco case, that you're effectively allowing people to recover for emotional disturbance alone. Unless there's any other questions from the panel, we do ask that the trial court's judgment be affirmed.
Thank you.
I'm going to start with the Transamerica case and then hopefully return to some of those fear of AIDS cases from the mid-90s from other jurisdictions. As counsel pointed out, Transamerica did arise from a policy of insurance, and it did interpret that policy according to the quote-unquote common sense and ordinary meaning. But it also said in that case, quote, in insurance law, the term bodily injury is narrower and more restrictive than personal injury. Bodily injury encompasses only physical injuries, impairment of physical condition, sickness, disease, or substantial pain. So I think it was very explicit in Transamerica that that term it's basically a term of art within the insurance industry, and it is different than the physical impact rule for tort purposes. And I think that's quite clearly set forth in Burns, and I won't belabor the language in Burns that's cited in the papers. I won't belabor the language from the restatement that's cited in the papers. I would, though, just to kind of draw it out a little more, point out the language of Valley National Bank versus Brown, another critical case that was decided in 1974 during the time that the impact rule held sway. It said, but with a few minor exceptions, the rule is that where no malice or intent is shown, no damages may be awarded for mental anguish or distress of mind. The exception is the rule occurs when there is a physical invasion of a person or a person's security. It's a physical invasion of some sort, and that is qualified here. Now,
Counsel, if I can just get you over to Monaco.
Yeah.
There was a formal diagnosis in Monaco, isn't that right?
I believe there was, yes.
Is that relevant at all to our assessment as to what the requirements are to get through that Monaco gate?
I think that would be a question maybe later down the road for damages or for a jury. I don't know if you want to have a gatekeeping function of you have to have an expert opinion or a doctor's opinion, if that necessarily perform an effective gatekeeping. I've never seen that embraced in a case. And part of that also, I think we're kind of at an odd place here because, as Ms. Johnson has noted many times, most of the cases we're discussing are summary judgment cases or post-trial cases where there would have been expert evidence, there would have been a formal diagnosis. You'd have that in the record, but we're so early here, we don't have that. So I'm struggling with putting that as like a pleading requirement or a gatekeeping function and how that would work, because I feel like we're kind of square peg round hole here with a lot of these cases. And if I could now go to, I think, Burns, which I think would relate to this as well. And you also heard after Transamerica, and it is true Transamerica also discusses some of the NIED cases like Burns. Burns, again, Andy stories are, again, summary judgment cases. And I think that's really important because both those cases do very intensely weigh the quality of the evidence that was put forth on summary judgment. In Burns, I think this is important. It said, quote, some of the plaintiffs claim to be suffering mental anguish, but there's no competent evidence of any physical impairment linked to the specific plaintiffs. And then the court discusses at length the evidence that the plaintiffs had put forth in summary judgment. And it was an affidavit from a doctor who hadn't even examined a lot of the plaintiffs. He hadn't linked any of the harm to a specific plaintiff. And there wasn't any evidence that there was anything other than transitory physical phenomena. It's about evidence there, and we're not at the evidence phase yet. We're at the pleading phase. And so the stories are similar. I won't go into it since counsel didn't focus on it. Now, with respect to Ball was in an accident, that's true. But the court goes out of its way in Ball to describe his injuries during the accident as, quote-unquote, minor. Ball was no more than bruised, and I would submit that a blood draw is more than just you're bruised, superficial contusion, which doesn't even puncture the skin. That's all Ball had, and I think that's why that language is cited in Ball that says it really is just an impact. Now, real briefly, I'd like to talk quickly, if I can, about the fear of AIDS cases, because counsel said we did not distinguish them. If you look at a lot of these cases, I think what's important to remember is they're from the mid-'90s, and there was a lot of fear of AIDS. And I think when you look, for example, at Brown and D'Amelio, they both go on at length about how and I think an important context is that in determining the reasonableness of plaintiff's fear, they look at whether there was an established channel of transmission, second, whether HIV was present when transmission occurred, and the results of the tests. And they kind of set forth these additional requirements to state a claim that requires an acknowledged channel of transmission and whether there was HIV present, because a lot of these happened like somebody was emptying the trash and got poked and then they got scared. Here, actually, that's all met. There is an established channel of transmission, intravenous needle use. there was HIV present. And so we are, even within the fear of AIDS cases from the mid-90s, we're in a very different situation. And so Brown talks at length about how you have to have that established channel. D'Amelio also says that. And I think also an interesting quote in D'Amelio is that where there exists proof that a defendant's wrongful conduct was intentional or recklessly indifferent, a rebuttable presumption of exposure will arise. So they're very different. I agree they have a different kind of thrust, but I think even if we were to apply that about needing an established channel, that would be met here. So unless there are any other questions we'd ask, we get another chance to amend the pleading.
Thank you.
Thank you.
Thanks to both sets of lawyers for your briefing and your argument. We'll take the matter under advisement and issue a decision in due course. Now we'll recess for a bit to allow the next case to set up.